Hello and welcome to this edition of The Wire Live. On April 8th, which was yesterday, we saw the Supreme Court giving a judgment on a petition filed by the Tamil Nadu government. It was a plea against the Tamil Nadu Governor R N Ravi, and what he did particularly was to hold back as many as 10 bills passed by the state assembly. So the plea was against that action of the governor, and the two-judge bench of the Supreme Court yesterday gave a judgment which said that the governor's action was illegal and erroneous. And so we have with us senior advocate of the Supreme Court, Shadan Farasat, and just to help us understand legally what is the judgment, though the judgment is yet to be uploaded in the court's website. So there's a lot of reportage that has happened. So I'll also draw from that. And essentially, we want him to understand, want him to tell us how, the legal aspect, the legal part of the judgment. So Shadan, welcome to this live edition of The Wire. And thank you. Thank you. And thank you so much for giving us a little time, from your busy schedule. We know the court is open today, and yet you've just taken out time to, answer some of our questions. So without further ado, I will just start, the line of questioning to you, which is, basically everybody is talking about this judgment in media and in the political circles and social media everywhere as a landmark judgment. So why should we call this landmark?
Yes, I think that's a great question. So like you first, just I'll flag it that as of now, none of us have seen an actual final copy of the judgment, like you pointed out, because not yet been uploaded. So we are, whatever comments we are giving is based on the live reportage of the pronouncement of the judgment, which we take it covered all the, important and consequential parts of the judgment. But with that caveat, why is it important is that, you see, normally what happens is the court declares a law and it expects the authority, whatever the constitutional authority, in this case, the governor, to act according to it. But in this case, there was a bit of a history, and the matter had earlier come and the court had declared the law as well. And despite that, you had a governor who was not willing to act as per law, right? And then in a situation like that, what does the court do? Then it introduces two things. A, introduces a time limit for basically taking that action. And it also introduces a deeming fiction that if you don't take that action within a certain amount of time, in this case, it was 1 month for a certain category and 3 months for another category, then you effectively have deemed to give, have deemed to have given consent. And the reason for that is that what the governor seems to have been doing was what we colloquially call exercising a pocket veto. So in this case, the legislature of Tamil Nadu has passed legislations, more or less in the context of the powers of the governor himself in respect of universities as a chancellor. And for whatever reasons, he did not want to give consent to that. Now, under the constitution, under Article 200, when a law is passed by a state legislature and is placed before the governor for his consent, he has three options. Either if he feels that there is a conflict with a central law because it's a matter of concurrent list, then he can identify that conflict and refer it for the concurrence of the president, right? That's option one. Option two is that he really withholds the consent. And, along with that option, then he exercises the third option, which is both interlinked, and the court clarifies that, is that you withhold the consent, but you send it back to the legislature along with withholding the consent with a message saying that I think these provisions have these issues, please reconsider it. Correct? So it's basically a plea to the legislature from the governor saying, I feel there's a problem, this is the problem, and you reconsider it. So effectively two, either, or the third option, of course, is to give assent to the bill, right? So you either give assent, which is non-controversial. If you feel there's a conflict with a central law or potentially a conflict, then you can send it to the president, or you send it back to the legislature with a message. Now, this was a case where what had happened was the governor had been sitting on certain bills for a long amount of time, right? And in a year and a half back, in a matter relating to Punjab, where the same issue was arising because their different government was there, but same issue had arisen, and the state of Punjab had gone against the governor of Punjab. The Supreme Court had said that you cannot, sit on the bill. If you have to refer it to the president, then you refer it to the president, but you cannot sit on the bill. Correct? Now, after the judgment of Punjab government came, it seems that the governor claimed that he's referred the matters to the president. Correct? And thereafter, what this second round of bills had now come. So this was not a issue dealing with the first round of bills. Now, after that,
yes,
the legislature had repassed these bills and placed a repassed bunch of bills before the governor. Now, in that context, the Supreme Court held that the governor really didn't have an option but to give consent or assent to the bills. And the fact that he was sitting on it and effectively exercising what the court called a pocket veto was not permissible, because really that's not an option envisaged in the Constitution. Although the constitutional provision itself does not identify a timeline within which this has to be done. Correct? So that's the gray area which the governors in this case, this governor or otherwise also have been misusing. So to close that gray area, the court basically said, boss, you have to do it in a certain amount of time. And it has fixed for a certain category 1 month, another category 3 months. And it said that if you don't do it within that period, that is, inaction cannot be to your advantage. Therefore, if you do not act within that period, then there'll be a deemed consent as per law, right? So they have put a deemed consent. Now, the important thing is what are the introductions by the court in this matter, which is not there expressly in the Constitution. One is you put a timeline. The timeline was not there in the Constitution.
Correct.
So you have introduced a 1 month period and a 3 month period, right? That's point one. Point two, what has been introduced by the court in this is the deemed consent, right? The consequence of sitting on it was not defined under the Constitution expressly. But obviously, the intent of the provision is to ensure smooth functioning of the government and of the legislative process. So taking that into account, it said, boss, if you don't do it, there'll be a deemed consent. I think that's why it's called a landmark, because these two introductions do one very important thing. If you are a recalcitrant constitutional authority, such as this governor,
yes,
who refuses to follow the law, then you can't take advantage of it. You will lose the agency, as it were, and what you seek to prevent will anyways happen, because the court has created a deeming fiction. So that's why it's normally in constitutional matters, when you're dealing with constitutional authorities, the court is normally restrained in doing something like this, because once you've declared the law, the expectation is that all constitutional authorities will follow that law. But in situations such as this, where entities are clearly not following the law despite the clear declaration of it, I think the court was literally forced to do this, because it saw somebody who was not understanding what his constitutional mandate of his official position was.
Yeah. Okay. So basically, the court, what we saw was the judgment is going to break the deadlock that was continuing between the state government and the governor's office. And in the process, we've seen this timeline for the first time being set, which is of the Article 200 of the Constitution. And so Shadan has beautifully explained to us from the legal point of view what are the two main basic issues, reasons why we are calling this a landmark decision. And the other thing, Shadan, is also respecting the will of the people, isn't it? I mean, because this is an assembly constituting of legislators or lawmakers who were elected by through a proper election by the people, isn't it?
No, that's correct. So I guess, the more important question, taking from your question, is what is the function of a governor in the Indian system?
Right.
And really, is there a function? Speaking for myself, my personal view is we possibly don't need a governor, because the constitutional position really is that governor is really a figurehead, except some expressly given discretionary powers. That is, if the Constitution itself gives some discretionary powers to the governor, then that's all there is. Otherwise, he has to always act on the aid and advice of the Council of Ministers. And also on, if there is a legislative action, then follow that legislative action. So therefore, really, he's a figurehead. He's like, in the same way a crown is in UK, right? Now, in the context of a national polity, yes, you need a president, you need a figurehead, and there are a whole range of things for which, he or she is required. In the state polity, there really is not that much, except for maybe, calling of who to form a government, right, after election. That is one function which, constitutionally is relevant, which a governor can exercise. But really speaking, beyond that, because the power in our system lies with the elected arm, with the elected government and the legislature, the governor is really a figurehead. Unfortunately, in these cases, the governors have not understood their constitutional role, or have understood and consciously ignored their constitutional role, and therefore such situations are arising. And if they continue to do like this, I think the movement or the call for even removing the post of governor and thinking of some other alternative will only rise.
Yeah, it's a very important point you have made, because we normally take the governors to be knowing that, in the know of their constitutional position. And here this judgment has actually shown that if someone doesn't know or someone doesn't want to act as per the constitution, he or she can be put in place. And that's what I think the April 8th judgment of the Supreme Court did. One other thing, Shadan, I want to flag is also generally want to get an opinion from you is we have a federal system, and now we see this whole conflict that is rising, between the particularly the center appointed governors and the opposition states, how they function, how the Raj Bhavans function in those opposition run states. There's forever a conflict we are getting to see, and not just in Tamil Nadu, in Kerala, and so many other states, Punjab you mentioned. So with this judgment, how do you see the judgment in the light of this federalism and the center-state relations? Will it strengthen our Indian federalism?
Yes, undoubtedly. I think it will certainly strengthen. And like you flagged quite rightly, in the recent past few years, we have had a whole bunch of situations where in states where the ruling party is not the same as that in center, the governors have been used effectively to make it difficult for the ruling party of that state to govern. And in that context, basically, you've lost political power in that state. I mean, the ruling party at the center is also a contestant in most of these states. So they have not been able to win the people's mandate, but they try to steal the mandate or try to make it difficult for the one who has got the mandate through the office of the governor. So that's really what the political push and pull is happening at this stage. And I think what this, I mean, the law in respect of governor versus elected government is fairly well settled in India. Unlike the Delhi situation where you had a lieutenant governor and a UT with the assembly, where there was a little bit of a larger gray area given the constitutional makeup there, and which was sought to be resolved by two Supreme Court constitution benches, substantially done, but still some part of it remained. In the context of a full-fledged state where you have a governor versus either elected chief minister or the legislature, that law is fairly well settled. So there's not that much that the governors can do to misuse. But even in that very limited space, what we were seeing, and this is one instance of the governor of Tamil Nadu, even that very limited space, there was sought to be a kind of misuse or wrong usage of that power. And I think that has been partly and substantially at least filled up and prevented for the future time to happen by this judgment. Does it rule out that other such, I mean, maybe this kind of instance will not happen because obviously now there's a deeming fiction also in terms of legislature passing a bill and the governor's approval. But there could be some other aspects on which we could still see friction. But nevertheless, even on those things, I think this is a larger message that, listen, the governor is a nominal head. You have very, very clear mandate to, do only those things which under the constitution are in your discretion, which are very few. And otherwise, you have to go by the aid and advice of the elected government or go with the bills of the legislature. So I think that message has gone. In the next couple of years, we'll see if that kind of a pattern which was developing will stop, slow down, or it will not impact. My hope is, and I do think that it will certainly, if nothing else, will slow it down substantially, because this unconstitutional aggression which one was seeing from the governors, if I can call it that, I think that is going to possibly either recede, if not stop.
Okay, so we've spoken to what Shadan is talking about is from the legal point of view. I, as a student of politics, is also, I'm going to come back to Shadan for more questions, but I just want to intervene here and talk about see the April 8 judgment also as a student of politics, and I would see the traces, at least some traces of this as of the political kind of a political message message also in a way. I mean, like, it's a kind of a political failure, I would say, of the Narendra Modi government, actually, because for the person, the man in question is R N Ravi. Ravi was, and after his retirement, he retired as an IPS. He was an IPS officer, Kerala cadre, and retired in 2012. And after retirement, he'd been given a lot of these post-retirement plum post and oppositions. And these are like, I mean, you give those positions only to someone whom you really trust. And this, as a chairman of the Joint Intelligence Committee, as the deputy NSA, National Security Advisor, and all that we saw 2014, 2018. Then, of course, 2015, we saw him as the man, the trusted man of the Modi Sarkar, to become the interlocutor for the Naga peace talks. That was essentially, I would say, this position was also a kind of a political position, because it was to push the Modi's public image as that something that nobody can, that Modi can. I mean, jo Modi hai to mumkin hai, that kind of a message. And of course, because this subject was the most appropriate, I would say, because the Naga peace talks had been going on for the last 75 years since independence. So the BJP's whole, right to power has also been that 70 saal mein kuch nahi hua, 70 years mein kuch nahi hua. So this was something that the man could do. And we suddenly saw that this was a historic framework agreement signed in August 2015. And the man of the moment was R N Ravi, who would be taking it forward. And but now this is 2025. I'm talking about, say, for 10 years hence, when I'm looking back, that he just not only could not deliver that, but also became the governor there, citing that he would be able to deliver it, but yet he couldn't. Then there was also a similar situation that we saw unrolling in Tamil Nadu, a similar situation that happened with the local government in Nagaland too. That NDPP is also an ally of the BJP, but even then they said publicly that he was interfering in their day-to-day affairs. And this is all in public domain, and you can Google and see what all has happened. And I've also written a piece today for The Wire in case you need more details. And then we saw the man, his whole career as a governor only grew. He was sent to to an opposition-run state, which was the DMK-run state in Tamil Nadu. And then from day one in 2021, since when he went, we have been seeing him being in headlines to taking on that government. And this included not only just stalling as many as 10 bills or so many other bills also, and various other decisions, plus also walking out of the assembly when it was in session without giving the governor's address, which is also a part of a constitutional norm, constitutional traditions. So we saw him doing overstepping at many areas. And yesterday, on April 8th, seemed to be the one of the things, major things that we see going against him. But now the question is, he failed, I would say, though this was a political appointment, he failed on two counts. One was to help Modi, further his image of a strong man who could deliver things. Naga Accord was not signed, so there also I would count him as a failure. And then he came to Tamil Nadu and did all kinds of things against an opposition government. But that also, I think, yesterday's this judgment also shows that he was operating against the constitutional norms, and something that we saw Modi, after winning the 2024 elections, was trying very hard to show that he follows the constitution, he reveres the constitution. We saw a lot of those images, and that also I see now as some sort of a failure, from R N Ravi. But we're going to see what happens to him next. Why I am saying this is because I want to refer to a 2005 judgment of the Supreme Court, which was against Bhuta Singh, Congress's leader Bhuta Singh, who was that time the governor of Bihar. And he gave a suggestion to the then Manmohan Singh government to impose precedence rule in Bihar. And that case had gone to the court, and the court had passed strictures against Bhuta Singh as the governor, saying that he overstepped and he misled the Union Council of Ministers. So following that, we saw Bhuta Singh resigning from his position. So that's the reason I bring this question up, whether the next move of R N Ravi or of the Modi government will be to ask him to step down. So in time we'll get to see. But before I end, I want to ask the last question to Shadan about he's touched a bit about on this, but I still want to go back to him and to ask this question that you have already mentioned, and I have also that these opposition states and the governors are forever in loggerheads. We've been seeing this, and also, if you take the Kerala example, like because of the continuous taking on of the state government, the governor was also some sort of a reward was given to him. He is now the governor of Bihar. So, do you see this April 8th judgment as some sort of a full deterrent, or we see that every opposition state will have to go to the Supreme Court to get a separate judgment, exclusive for their state? Because why I ask this to you, Shadan, is that the Bihar judgment, when it happened in 2005, we saw a repeat done by the Modi government in Maharashtra, something very, very similar. So that's why my question to you.
No, of course. I mean, in a life of a republic, 15-20 years is also a long time. So, we are talking about 2005. We are in 2025. So 20 years have passed.
Right.
But I mean, I certainly cannot, speak for that far ahead in terms of 10-15 years. But I think for the foreseeable future, say 5 or 7 years, which, on this issue, at least, I think we have some clarity. Insofar as the conduct of this specific governor is concerned, I think there is an observation, and we'll know once the judgment comes out in print, that this governor did not act bona fide. He basically, and that's a very, very scathing observation. If it's come from the Supreme Court against another constitutional authority, that his actions were not bona fide. Normally, courts are very careful in coming to an observation that a constitutional authority is acting mala fide. If that is the case, then I think he should either resign or he should be asked to go. I mean, this specific governor will not have if the Supreme Court's finding on mala fide are there, he does not have a constitutional or a moral right to continue in that position. And in the long term, how things will pan out, I think let's see. But federalism is always in play. I mean, there is sometimes, you have spaces where the central government is a little more powerful. They try to overassert themselves, and then there is a corrective mechanism. So I think we are in that cycle of corrective mechanism. And let's see how much of the correction that we actually see on the ground. And of course, only time can tell.
Yeah, right. So as you said, it's also the test of the Modi government. If it is actually that kind of observation has been made from the Supreme Court, what would be the government's next move? So with that, I end this live show of The Wire. And thank you, Shadan, for joining us once again.
Thank you.